If you saw the first video in this series, you know that proving fraud is a series of 7 checkboxes. If you haven't, it may be worth watching so that you have a general understanding of the legal requirements for proving fraud in a real estate transaction, especially in Texas. But for now, here's where we pick up. You have a legitimate case. Every box is checked. Now you have to figure out if it's economically worth it for you and for the attorney. Now, those are two very different conversations. Let's get into it. Another day, another solution. Let's talk dirt. So, before we get into the economics of a real estate fraud case, as I promised, let me tell you what kind of channel this is. Being the bearer of bad news isn't always popular. It doesn't always lead to more business for attorneys. Some people come wanting validation. They want to hear, yes, you were wrong. Let's go get them. That's human. It doesn't make them wrong, but that's not this channel, and I'm not that type of attorney. Justice and economic reality don't always land in the same place, and the attorney who tells you only what you want to hear isn't serving you well. So let's talk about something that many people never expect to hear. You can have a solid case, brutal injury, all check boxes checked, and still end up walking away. Not because the fraud didn't happen, but because the economics don't line up. That's a hard thing to hear, but it's the truth. And always remember this. Whoever said Lady Justice is blind, they certainly were not talking about the costs of the courtroom. The cost of litigation has just as much to do with your ultimate success as the facts of your case. So for the purpose of understanding, let's get into a quick example. Let's talk about contingency fees. You find a contingency fee attorney and he takes your case. There is no upfront costs. It is a split with that attorney on a percentage basis. You win, they take about 40%. You lose, they get nothing. Now, for a lot of people, it's the only way they could afford to litigate. Now, here's what most people don't know. Contingency is largely a creature of personal injury law. It's born there, it thrives there, and the economics support it there. Why? Because in personal injury, there's almost always an insurance company at the end of the case, a funded entity writing the check. Someone gets hurt, the attorney takes the case, insurance pays, nobody sees the bill. In most other areas of law, however, including real estate, contingency is the exception, not the rule. In real estate fraud, usually just the person at the end, no insurance, no guaranteed check. People walk in assuming contingency is just an option, like ordering off a menu. It's not, and we'll go deep on exactly why in the next video. So let's delve a little deeper into the piece of this puzzle that most people never see coming. In real estate fraud, there's no insurance backstop in most cases. Insurance usually covers negligence or accidental harm. Now, because fraud is intentional, and intentional acts are explicitly excluded from virtually every standard policy, insurance generally does not play a role in real estate fraud cases. The seller who lied about the foundation, the agent who hid the flood history, none of them are going to have coverage for what they did on purpose. Now, this is Texas law, so if you're in another state, you need to check with a local attorney. When you win, you're collecting from an individual who may not have the money, who may have moved assets, who may file bankruptcy. Winning the case and collecting the judgment are two completely different problems. So you may be asking, Rick, if a case is that good, why would a seasoned real estate attorney pass on the case on a contingency basis? Well, it's not because the case isn't real. It's because they've done the math. Expert witnesses, appraisers, construction experts, engineers, every one of those is going to cost real money. Depositions, filing fees, years of litigation. Seasoned attorneys run this math before they ever open a file. That's not cynicism, that's experience. So let's run the actual math on what winning may look like so we can get a sense of real numbers. Let's say you've checked all the boxes, your evidence was really strong, you spent years of litigation, and you win. You picked the perfect attorney. The jury awarded you $50,000, and your attorney is on a contingency of 40%. Right off the top, we're going to take away $20,000 for the attorney. Now, from the $30,000 that's left, we need to subtract litigation costs, experts, depositions, filing fees. Even in a lien case, we may be left with about $15,000. $15,000, Rick, after years of litigation? Yes. Now, what if the repairs cost more than that? Yeah, you won. Big deal. You're still underwater. Now, for the attorney side, we take the $20,000 gross, we minus their share of their costs, and we minus all the years of their time. See, the math doesn't work. They knew it before you walked in, and they still took the case. Now, even beyond the money, there's something else built into every contingency arrangement, a structural tension that most clients never even think to ask about. Even on contingency, the attorney's interest and the client's interest don't always point in the same direction. It's only natural that the attorney may want to close and get paid. The client needs enough to fix the property. A settlement that works for the attorney's math may leave the client still underwater. That's not an accusation, it's just what happens when incentives diverge. Know this before you sign anything. So here's what this looks like in practice, especially when somebody doesn't know any of what we just covered. They keep shopping. When experienced attorneys pass on their case, they assume the case is weak. Sometimes it's true, but sometimes it's not. Often, the experienced attorney is passing because they've run the math. Not every attorney who says yes, however, fully understands what they're getting into. And the client who finds that yes, they may navigate those surprises right alongside their surprised counsel. I want to shift gears for a moment because not every decision is purely about the economics. What if you want to pursue this out of principle? You were wronged, you want accountability. That's completely understandable. When someone pays out of pocket, not on contingency, a lot of options open up. The whole conversation changes. But I'll be straight with you. Principles are a valid reason to pursue a case, but principles can also be very expensive. Go in knowing both of those things, and you'll be just fine. So let's recap what we covered today. We've got a real case, a real injury, and all the boxes are checked. And yet, the economics still may not line up. Now, that's not a reason to give up. I'm not trying to be Debbie Downer, but it is a reason to go in with your eyes wide open. In the coming videos, we're going to delve deeper into real estate fraud and we're going to connect a lot of dots. Just know this, we're just getting started. This channel is going to grow from the broad strokes, foundational concepts, all the way down to very detailed deep dives on the specific issues that actually affect your situation. The more you follow along, the more it will compound. Each video builds on the last, and the deeper we go, the more useful it will get. So if this was helpful, like the video, subscribe to our channel, and turn on notifications so you don't miss what's next. If you need help with a matter, you can contact us in the link below.